Hi, I'm Chris Mutimer, a founding partner of Monument Legal. If you're watching this, you or someone you know is likely facing a DUI charge in Washington, D.C. This can be a stressful and confusing time, and it's important to understand your rights and options. In this video, we're going to break down what a DUI is here in D.C. We're also going to discuss the laws that govern it, how field sobriety tests work, the admissibility of preliminary breath tests, what to do about statements made to the police, testing back at the precinct, and most importantly, how we at Monument Legal can fight your DUI arrest. We'll also discuss diversion options like a DSA and drug court and strategies to minimize penalties with a focus on avoiding jail time whenever possible. So let's start with the basics. What exactly is a DUI in Washington, D.C.? In D.C., a DUI, or driving under the influence, is defined as operating a vehicle while impaired by alcohol or drugs. You can be charged with a DUI in two primary ways. First, if your blood alcohol content level, your BAC, is at a 0.08% or higher. This is known as a per se DUI. Second, even if your BAC is below a 0.08, you can still be charged if the government can prove that you are impaired to an appreciable degree. Operating while impaired, also known as an OWI, means that the government believes that you are impaired to that appreciable degree. The penalties for DUI can include fines, license suspension, mandatory alcohol education programs, and even jail time. A DUI in DC carries a penalty of up to 180 days in jail and or a $1,000 fine. DC also has mandatory jail time for repeat offenders, high alcohol scores, drug use, and even having minors in the car. The legal penalties for an OWI or DUI vary based on factors such as a BAC level, prior convictions, and the presence of aggravating circumstances. Now that we know what a DUI is, it's important to understand the laws that govern it here in the district. DUI law in DC is primarily governed by the DC municipal regulations and relevant case law. These laws outline the specific BAC limits, the procedures for testing, and the penalties for conviction. It's crucial to understand that DC has implied consent laws. This means that by driving in DC, you've implicitly agreed to submit to chemical testing if lawfully arrested for a DUI. Refusal to submit to testing can result in a separate license suspension in addition to the DUI charge. So let's talk about what happens during a DUI stop, starting with field sobriety tests. One of the first things you might encounter during a DUI stop is field sobriety testing. But we want to ask, how reliable are these tests? Police officers often use standardized field sobriety tests, or FSTs, to assess impairment. These tests typically include three key components: the horizontal gaze nystagmus test, also known as the HGN. This test involves the officer observing your eyes as they follow a moving object, many times a pen. The officer is looking for involuntary jerking of the eyes, which can indicate alcohol or drug impairment. Second is the walk-in turn. This step requires you to take 9 steps heel to toe along a straight or imaginary line, turn in a specific manner, and then take 9 steps back towards the officer. The officer is looking for signs of imbalance, improper turning, and difficulty following instructions. The third and final is the one-leg stand. This test requires you to stand on one leg with the other foot raised about 6 inches off the ground while counting aloud for 30 seconds. The officer is looking for swaying, hopping, using your arms for balance, or putting your foot down. It's important to know that SFSTs are often subject to error by the officer. Factors like road conditions, lighting, and even an individual's physical abilities can affect the results. At Monument Legal, we have experience challenging the validity of these tests. Another common element of a DUI stop is the preliminary breath test, or the PBT. Let's clear up some misconceptions about this test. The PBT, often administered as a roadside, is a preliminary breath test. and it's designed to give officers an initial indication of your BAC. Now, an officer may use the PBT to establish probable cause for their DUI or OWI arrest. However, in the District of Columbia, this test is not admissible in court to prove guilt. However, it can be used by an officer to decide whether or not there is probable cause to arrest you. Its reliability is often questionable. At Monument Legal, we understand the limitations of PBTs and will scrutinize their use in your case. During a DUI stop, it's also crucial to understand your rights, particularly when it comes to what you say to the police. Remember, when in doubt, don't say anything. Anything you say to the police during a DUI stop can and will be used against you. Remember that the officer is most likely wearing a body-worn camera in the middle of the chest, and that camera is recording anything that the officer observes and hears. It's crucial to remember your right to remain silent and your right to an attorney. You can politely decline to answer questions beyond providing your driver's license, registration, and insurance. A proper statement would be something like, under the advice of counsel, I am exercising my right to remain silent. Even seemingly harmless statements like, I only had one drink, can be used against you as evidence that you admitted to consuming alcohol. In many chances, especially if you were to go to trial, this will be offered to a jury or judge to show that you've admitted to having a drink. Contact Monument Legal as soon as possible so we can advise you on how to proceed. If you're arrested for a DUI, what happens next? Let's talk about the alcohol testing process back at the police precinct. After an arrest, you'll likely be asked to submit to a more formal breath, blood, or urine test at the police precinct. These tests are generally being recorded by surveillance cameras, so keep in mind that the way you act is all being recorded. There are specific procedures that must be followed by the police when administering these tests, and any deviation from those procedures can compromise the results and allow us as your attorney to get them thrown out. We'll examine every aspect of the testing process to identify any potential errors or violations of your rights. While you have the right to refuse to submit to chemical testing, know this: doing so will likely result in the suspension of your DC driving privileges for up to 1 year. However, if you've been drinking or have used drugs, it may be wise to refuse the test to avoid giving the police direct evidence of your alcohol or drug use. So, we've covered a lot of ground, but the most important question is, how can Monument Legal help you navigate this complex situation? If you or a loved one are facing a DUI charge in DC, don't wait. Contact us today at Monument Legal. We are here to provide you a confidential and free consultation. We're to protect your rights and guide you through this challenging and scary process. Thank you for watching. Take care.